Thank
So
you.
what we remark is further affidavit and
The further
effort in terms of which section of the Inquest Act we have to read it into the
as the court pleases, we propose. I initially anticipated making an application to reopen, and then when I looked at the provision of the Inquest Act itself, and the fact that the inquest by its nature is investigatory, the provision of Section 13 will be applicable in a receipt of this affidavit. It allows your ladyship to receive it and dispense with the attendance of the deponent of the affidavit, although he is present, cannot stay. If I may read that provision, it says, upon production by any person or any document purporting to be a statement under oath or affirmation by any person in connection with the death or alleged death in respect of which an inquest is held, or any certified copy thereof, shall at the discretion of the judicial officer holding the inquest be admissible as proof of the facts stated therein. There is then proviso which reads, provided that the said judicial officer may admit any statement which is not so admissible, or any certified copy thereof, if that judicial officer, having regard to one, the form and contents of the document in which any such statement is contained, B, the availability of any person who made any such statement, C, the probative value of any such statement, D, any prejudice to any person which the admission of any such statement might entail, and E, any other circumstance which should, in the opinion of the judicial officer, be taken into account. It proceeds, is of the opinion that any such statement or certified copy thereof should be admitted in the interest of justice. Our submission is that in terms of this provision, the statement can be received. It is the issue of time and the fact that today the matter was actually set down for purposes of argument by the state, that we propose to proceed in this fashion by reading the statement itself. Colonel Stein, who deposed to this affidavit, is present in court. However, he has actually testified before this court. He was called, I think, on 2 occasions. And since the statement is mainly to deal with one aspect, just the name in particular of the individual who allegedly witnessed the assault on Chief Albert Luthuli, that young boy of the Mnyandu family, and who he was, it deals pertinently with that. And we propose, therefore, that the reading of the statement will suffice without having to call Colonel Stein.
Thank you, Mr. Nolan. The ruling by the court is that pursuant to the provisions of Section 13 of the Inquest Act, this court allows the sitting of the further affidavit by Lieutenant Colonel Stein, who has previously testified before this court, and also the accompanying photo album which is attached to the statement. And the reason behind all this is that it is in the interest of justice that the further statement be admitted, and further that there isn't any need for Lieutenant Colonel Stein to testify under oath, saying that he has already testified before these inquest proceedings on at least 2 occasions. The statement will be marked as Exhibit
Double F.
F, and the accompanying album will be marked F1.
Double F1, as the court pleases. May I, with the leave of the court, proceed to read the statement into the record,
Yes, Mr.
as the court pleases. The statement reads thus: Thomas Johannes Adolf Steyn declares under oath in English Colonel MP Dlomo. Paragraph 3, I was informed that a witness, Buffy Isaiah Mdleje, who already testified in the matter, agreed to point out his older sister who, as she was able to confirm the name of the boy who allegedly witnessed the incident which possibly caused the death of Albert John Luthuli in 1967. The boy disappeared shortly after the incident and was never seen again. Paragraph 4, on 4 August 2025 at 9:42 in the morning, Mdleje took me to the house number 861 Tuzuma and introduced me to Cecilia Ncele. On arrival at the house, she was still in bed. She had been ill for some time. She is 84 years old. She informed me that in 1967 she was most of the day in Umlazi, with her father, and only slept at home. The name of the boy who disappeared is Mbemu Mnyandu, and he was about 4 years older than her. Paragraph 5, during the interview, Buffy Isaiah Mdleje interpreted from the English language to Zulu and vice versa. Mrs. Ncele cannot see or hear well and struggles to walk. Buffy Isaiah Mdleje informed me that he and the other family members do not want her to be involved as a witness in court proceedings as she is ill. Paragraph 6, I took a photo of her identity document, an identity card, and 2 photos showing her general appearance with my official cell phone, Galaxy A24, and later compiled a photo album and a key to the photo album. Paragraph 7, I know and understand the contents of the statement. I have no objection to taking the prescribed oath. I consider the prescribed oath to be binding on my conscience. I swear that the contents of the statement are true, so help me God. It is signed by Thomas Johannes Adolf Stein, the colonel, and it is commissioned in Durban on the 27th of August 2025 at 8:45 in the morning by a warrant officer C.J.C. Smith as a commissioner of oath. Attached to it is what has been now marked FF1, which is the photo album, which contains the photos. Photo 1 indicates the identity card of Cecilia Ngcele. Photo 2 and 3 indicates the general appearance of Cecilia Ngcele. The key to the photo album is prepared by Lieutenant Colonel T.J.A. Stein after photos were taken on the date at house number 861 at Induzuma, and this is signed, and the photos are indicated and attached here too. The original of the statement has been handed to the court. Yes, the ID number of Mrs. Ngcele is as follows: 401170324084. She was born in November 1940.
Just repeat that, Mr. Noor.
It is 4011.
Okay.
70324084. So in November this year, she will be 85, now 84. I seek leave to have the statement accepted into and to form part of the record of these proceedings.
Thank you, Mr. Noble. In 1967, she must have been about 26 years old.
Correct.
Thank you. That will be Exhibit FF, and the photo album with the accompanying key to photos is marked Exhibit FF1.
As the court pleases. My lady, just...
Although the photographs, the ID photo is not commissioned, but the court will accept it on the strength of the affidavit of Lieutenant Colonel Stein.
As the court pleases.
Thank you. We have Mr. Madlebe as our interpreter. I do not know whether we need just to interpret this piece of evidence for the benefit of the public. Not that they don't understand English, but sometimes because we are facing the court and not facing them, some
yes.
of the words that you have been reading into the record may not have been caught up by other people. Mr. Madlebe, can we use your services, please?
Certainly, I will summarize my letter, and I apologize for my later one.
Please.
You got it, okay?
I'm sure you can stand up, Mr. Major.
Perhaps
Yeah.
take that position.
Thank you.
Ngamafuphi-ke umshushisi bekade efundele inkantolo isitatimende esabhaliswa yilowo abeke esiqobelo thini athathe intambo njengomphenyi kulona lolu daba lokudlula emhlabeni wenkosi uLuthuli. Ngamafuphi lesi sitatimende sabhaliswa yilowo amagama akhe angu-Thomas Johannes Adolf Steyn, nokuyilapho echaza khona ukuthi emva kokuthi-ke esethabathe iy'ntambo ephenyeni kwalo lolu daba kukhona ubufakazi obabe abe esekuqoqa ukuthi-ke waziswa ngofakazi ukuthi-ke ongubafi izaya letho osukathula ubufakazi kulolu daba owabe-ke esevuma ukuthi-ke angakwazi ukuthi-ke ayokhomba udadewabo ayomkhombisa udadewabo omdala ukuze aqinisekise igama indaba yegama likamfanyana lo ekuthiwa wayekade esibonile isigameko sokushona kwenkosi uLuthuli ngesikhathi senzeka laphana ngonyaka ka-1967. Kepha-ke kuyavela phenyini ukuthi-ke lo mfanyana wabe-ke esenyamalala kumbe eseduka emva kwesikhashana nje isigameko senzekile futhi-ke akaphindanga kwenzeka. Kuyavela futhi ophenyini ukuthi-ke kwathi mhla enyangeni kaOgasti ngonyaka 2025 isikhathi okulapha.
Insurance is easier when you're naked. Here are 5 things you can do on the Naked app.
Ngokwelapha afika esengithula khona umama usisila ngabe ngifika laphana kuyamuzi ngabe sengithola ukuthi ubambekile akekho mnandi empilweni futhi-ke usembhedeni wabe-ke esengaziswa nanokuthi sekunesikhathi eside ebuthakathaka engaphilile engekho mnandi empilweni nanokuthi iminyaka yakhe ubudala isingu-84 wabe-ke esengazisa nanokuthi ngonyaka ka-1967 isikhathi esikhulu laphana emini uyena wayekade esuke khona laphana esitolo eMlazi enomama wakhe nanokuthi uyena futhi wayekadela lakhona laphana ekhaya nanokuthi-ke igama lomfanyana lo owanyamalala igama lakhe umbhemu mnyana futhi wayeneminyaka cishe emine ngalesi sikhathi. Lesikhathi-ke kubanjwe yona lengxoxo ubafika wayekade etolikelwa ususa elimeni lesingisi kuyiswa elimeni lesizulu kuye kususwe kulesizulu kuyiselwe kulesingisi. Umama uwumuntu ongasaboni emehlweni futhi akasakhoni ukuzwa kahle ey'ndlebeni futhi akakwazi ukuzihambela. Ubafi izaya mvejo wabe esengazisa wangazisa ukuthi bona namanye amalungu omndeni abakuthakaseli abakuthandi ukuthi eze lapha mbona enkantolo azokunikeza ubufakazi. Yaqhubeka-ke uSteyn ukuthi-ke ubeke wabe-ke esethatha isithombe nokuyilapha ekade eshutha khona ikhadi eliwumazisi wakhe umama uMgeje esebenzisa ucingo lakhe lasemthethweni lasesiphoyiseni ehlobo le-Galaxy A24. Uyaqhubeka-ke nokuyilapha eqinisekisa khona ukuthi uyakhona lokhu kuqukethwe esitatimendeni sakhe uSteyn futhi-ke akaphikisana nokuthi athathe isifungo esisemthethweni kulona udaba emva kokuthi sibhalisile isitatimende nanokuthi futhi-ke isifungo usibuka ukusibheka njengalento ekubophezelayo unevezwa ngaphemva kwalokho ube esefungo wabe-ke esefundiswa uSteyn ukuqinisekisa ubuqotho engusobaso nesisitatimende. Inkantolo-ke bese kuthwele ithibinzayo sona lesi sitatimende sa-Steyn kanjalo nezithombe ey'tshengisa umazisi wakhe ugogo uMgeje kanjalo nebhasi lakhe.
Sorry, Mr. Matlebe, I'd like you to go back to paragraph 4. It's not that he was 4 years old, he was 4 years older than her.
Thank you, manje. Kanti-ke ukulungisa laphana iphutha elenzekile esigabeni sesine nokuyilapho umusheke khona ngohlobo oluthi wayekade eneminyaka emine edala okusempeleni wayekade emdlula ngeminyaka emine ngokudala. Thank you.
Thank you, Mr.
As the court pleases. My
Thank
lady.
you, Mr. Matlebe. I don't know whether Mr. Matlebe needs to interpret the argument. Normally, it's not interpreted.
Normally, it is not interpreted, my lady.
Yes.
In a normal cause, it's
No,
usually
it's fine.
the legal
Mr. Matlebe,
is
you may take
exchanging
a seat
blows.
as
Thank you so much.
As the court pleases. My lady, just for completeness, I've just as I was preparing this statement, I was handed a document issued by the Home Affairs Department today, which the investigator obtained this morning. It's dated, today is the 13th of October. It's dated the 30th of October by the Department of Home Affairs. It's a confirmation of the death date of Dr. Jacobus Johannes van Zyl.
Yes.
If the court will be so amenable, may I, as I'm doing this, hand
Hand it
this
in. Yes,
as part
certainly.
of that other document as well?
Uh,
Or maybe a
Yes,
different,
you may hand it in.
as the court.
We will have to align it with the evidence that pertains to Dr. Steyn.
Correct.
Sorry,
To-
Dr. Van Zyl.
Yes, correct.
We can give it a provisional label,
Yes.
like FF3,
Uh,
but we, as in due course, we will align it to
Or-
the particular evidence
yes.
that pertains to the whereabouts of Dr. Van
Dr.
Zyl.
As the court
I think
pleases.
we do have
Evidence.
some evidence pertaining to these different doctors.
Yes,
But
correct.
for now, we will accept it as exhibit FF3,
As the court,
FF2.
as the court pleases.
Thank you.
If I may hand it, there was evidence handed to, testified to the effect that Dr. Van Zyl is deceased.
Yes.
However, it was based on other investigations, but now at least there is something from the Home Affairs Department indicating the date of death.
Yes, we've accepted into the record by virtue of the same section 13 of the Inquest Act as FF2.
As the court pleases.
Inkantolo iyaqhubeka futhi iyamukela futhi iyetha njengofakazi phecelezi njengozibithi u-FF2 ukuthi-ke umshushisi leli khasi adlulisele ithebeza lenkantolo ikhasi lokufakazi liqinisekisayo livele laphana emnyangweni wokwendaba zabantu phecelezi wa-Home Affairs eliqinisekisayo i-date ashona ngayo uDokotela Van Zyl. Kuyavela ukuthi ubufakazi obethulwe buvele kudanile ukuthi usadlule emhlabeni isiqinisekiso esivele emnyangweni wokwendaba zabantu obesikhathi esingekho isona-ke sesethulelwe inkantolo bese ivumelana futhi nomshushisi ukuthi njengoba-ke njengamanje sekufika esigabeni lapho kuzokwenziwa khona izethulo zokugcina ukuthi ekutheni inkantolo igqugquzele ekutheni mayikhiphe siphi isinqumo mayelana nalolu daba. Leso sigaba ngokujwayelekile emacaleni siye singahunyushwa kumbe singatoliwa bese ivuma-ke inkantolo ukuthi lesi sigaba la umshushisi benza khona izethulo zokugcina leyo ngxenye yona ayizukuhunyushwa ngenxa yokuthi vele izinto inkantolo eyayithinte kuzona ngokujwayelekile vele uma ngabe seyinikeza isinqumo sayo ziyaye zivele kulesinqumo senkantolo.
Mr. Ngobe, also for the sake of completeness,
Yes.
it records that he died, Dr. Van Zyl died on the 21st of December 2014.
Correct. Yes.
Kanti-ke lela khasi liyavela ukuthi usuku adlula ngalo emhlabeni uDokotela Van Zyl ngomhla wama-20 emuva enyangeni kaZibandlela December 2014.
Thank you. My lady, maybe just for completeness again, then that would be the close of the case,
Thank you.
as the court pleases.
Close
Advocate
of
Dunya will,
the evidence
yes,
by the
prosecution,
prosecution team.
as the court pleases. Advocate Dunya will outline how we will go about presenting the evidence.
evidence may I handle?
Advocate Dunya.
As the court pleases, my lady. My lady, before we could even commence with addressing this honorable court, I would ask to start by acknowledging the witnesses who came before this court and gave evidence. But my lady, I would like to, in particular, acknowledge and appreciate the Luthuli family. Despite the hurdles they came across as of September 1967, they never lost hope that one day they will be afforded an opportunity to challenge the finding of the Inquest court and the narrative that emerged from the 1967 Inquest court proceedings. My lady, the court can attest to the fact that Dr. Albertina Luthuli was of advanced age when she had to testify, but she showed excellence in her recollection and her desire to have the issue of the death of his father dealt with and laid to rest. By the same token, my lady, I wish to acknowledge the persons of the Honorable Jeffrey Tamzana Hadebe, who was one of the persons who raised his hand when the prosecution was seeking to understand the role of Chief Albert Luthuli within the liberation movement. As we acknowledge the work of the members of the Directorate of Priority Crimes, starting with the previous investigators, your Captain Khamanyane, Colonel Montle, who at a time when we were at crossroads, they went above the call of duty in tracing, amongst others, the locomotive which was presented as evidence, and also securing experts who assisted during these proceedings, experts like Warrant Officer Bedges and Sunet Nell. And my lady, I want to remind the court what they had to say of the inroads they had to make to get those witnesses when procuring services of private experts proved difficult, where they had to conduct consults with the members of the crime scene management unit, so as to ensure that the expertise that could not be secured privately are found within the South African Police Service. My lady, I will be doing a disservice if I were not to acknowledge Leslie Labaskachne, who at no cost to the state was willing to provide us with his expertise and willing to come before this court and testified, and so did Mr. Van Tonder. My lady, as I've said, I'm not about to name all the witnesses, but the state does acknowledge that without them, this case might have not been brought to this court. Individually and as a collective, they assisted the prosecution to gather the necessary evidence to persuade the director of public prosecutions province, the national director of public prosecutions, as well as the Minister of Justice, that there is evidence that necessitates the reopening of this case. My lady, we will deal with that evidence as we proceed from today onwards. Now, my lady, I want to turn to the proceedings themselves.
Mr. Junior, if you can indicate when you want to take an interval.
My lady, we may, because now I'm about to start addressing court on the merits of the case.
Yes, I think then we can take a 30 minutes adjournment.
As the
Then we will then delve into the proceedings themselves.
as the court.
Let's adjourn.
Yes, what is my lady? As the court is alive to the fact that the prosecution has filed written heads of argument in this proceedings. Those heads constitute the body of our argument. Today and the days to follow, the state is not necessarily to repeat its heads of arguments that have been filed with the court, but rather to deal with certain aspects of this case, which might necessarily be covered in our heads of argument. I'll briefly give this court a breakdown of the issues that are going to be covered by my colleagues during the course of our address. We are to look at the effects of apartheid as an institutionalized practice. We will do that as it is relevant in these proceedings. Or further to look at the narrative that found its way from the judgment of the initial inquest court.
The 1967.
The 1967 inquest. My lady. We will further look at the modus operandi and as it talks to the elimination of political activists in the country. We will make particular reference to the inquest of Imam Aaron, the Timor, Hafeji, and others. We will have, unfortunately, to look at apartheid as a crime against humanity, as well as other crimes that might have been committed against Chief Albert Luthuli, and those that we would submit ought to be found responsible for his death. Ms. Trene, Mr. Msimango, as well as Mr. Ngogo, will deal with those issues. As I will once more deal with the prayers as contained in our heads after they have addressed the court. Having said that, my lady, I want to take this court and track back to the beginning of these proceedings. That was on the 14th of April this year, when giving effect to an instruction from the then Minister of Justice and Correctional Services, Ronald Ozila. This court declared reopened the inquest into the death of Albert John Luthuli. This was a process after the National Director of Public Prosecutions had approached the minister with submissions based on evidence to have the inquest reopened. The minister obliged in terms of Section 17A, capital A, of the Inquest Act, which provides as follows. The minister may, on the recommendations of the Attorney General concerned, at any time after the determination of an inquest, and if he deems it necessary in the interest of justice, request a judge president of a provincial division of the Supreme Court to designate any judge of the Supreme Court of South Africa to reopen that inquest, whereupon the judge thus designated shall reopen such an inquest. On the 14th, when my lady reopened this inquest, he was giving effect to the decision that was arrived at by the minister. My lady,
I will appeal to the people who are between the opponents in the public dialogue to cease doing so. It's not good to court declared, and that is why we have breaks instead of going throughout the sitting here in court. The break is designed to give people a chance to go outside of this courtroom and do whatever they feel they can't do in this court. But for the benefit of those who do not often come to court, it is found upon when people eat or have a snake inside court. The recordings, these machines are very efficient in recording, and they do make a noise. I've been hearing that sweets are being unwrapped or chocolate. It's a bit of a disturbance to other listeners and also to the advocates and also to this court. Please, good people, let us refrain from having snakes inside court. It doesn't overwhelm.
Kadolobe, siyacela ukuthi kuyabonakala futhi kuyezwakala ukuthi bakhona abaqaqa izinto ezifana noswidi nakuchocolate nabamukugana bahlafuna phakathi lenkantolo ukuthi lenkantolo kuyisenzo esingabukeki kahle nesingehli kahle ngokwesithunzi nesidima sayo enkantolo ingawo futhi-ke kuba khona amakhefu ukuthi kulokho kuyo amakhefu wenzela wona lokho ingalelo seyiyana ukuthi-ke abenze njalo mabapheze ukwenza njalo ikakhulukazi futhi ngenxa yokuthi imishini yokuqopha uma ngabe uqoshwa enkantolo lesetshenziswa ibukhali kakhulu iyekwazi ukuyicosha imisindo efana nokuqapha amaphepha abo osuku bese-ke aphazamiseka ukuqoshwa enkantolo iyabaningi abenza ukuthi baphele ungaqapha osuku ungahlafuna ungadlula ngaphakathi enkantolo udaba.
On a lighter note, I've always wondered why sweet breaking and chocolate breaking make noise. And I think it is to entice other people to go and buy it.
Umakhelwane ewuqada abese yeza umakhelwane ukuthi awunami uyoqada bese naye nalo nje ukuthi naye uzothenga ngalolu yabo nje basonge ibandla kusuku.
Thank you, Mr. President. You are still on the point of my concentration got lost after you said something about the reopening of this inquest.
My lady,
Giving effect to the organization by the Minister of Justice at the time, who was Ronald as just take from me.
as the public is my lady, did your ladyship capture the reading of the provisions of section 17, capital A?
No, not yet.
As the
I
public
said that was a mistake.
as the public is my lady. My lady, Minister Lamola was acting within the scope of the provisions of section 17, capital A, which provides that the minister may, on recommendations of the Attorney General concerned, at any time after the determination of an inquest, and if he deems it necessary in the interest of justice, request a judge president of a provincial division of the Supreme Court to designate any judge of the Supreme Court of South Africa to reopen that inquest, whereupon the judge that's designated shall reopen such inquest. This is what was empowering the minister to do as he did. But my lady, the minister does not just thumbs up and act according to the provisions of section 17, capital A. The minister needs to be provided with evidence that shows that it is in the interest of justice for him to exercise the discretion that he has in terms of section 17, capital A of the Inquest Act. My lady, in providing such evidence, the prosecution dealt with the issues that are contained in our heads at paragraph 11, page 3. These are the issues which, as a prosecution, we had to address both to our national director, because the national director, as well as the director of public prosecutions, and the minister, those three bodies need to be convinced that there is a case that requires the reopening. And we had to look at whether there exists evidence which was not presented before the initial inquest, necessitating that the court make a fresh finding in terms of section 17A, subsection 3, read with section 16, subsection 2 of the Inquest Act of 1958, of Act 58 of 1959, I beg your pardon, my lady. We had to look at that evidence. And I submit that the very question which we had answered to the persons that I've referred to is the same question that is before this honorable court to answer. Whether indeed the prosecution has presented evidence which was not part of the body of record of the 1967 inquest. And I submit, as this issue will be dealt with more in detail by one of my colleagues, that yes, we have presented to this court scientific evidence which dealt with whether it could be said that the inquest, the initial inquest, had an opportunity to look at the evidence of Labatskachne, evidence of Van Tonder, as well as the evidence of Dr. Nzele, which then we dealt with those. But we are saying to this court, is this court agreeable? Is this court confirming that such evidence was not part of the initial inquest proceedings? My lady, again, when we dealt with the authorization that we sought from the Honorable Minister Lamona, we had to pertinently deal with the question of the prescripts of the Inquest Act. As spoken of in the Timor case versus the Magistrate of Johannesburg, which case is part of our heads of argument, and it will be found at page 4 of the heads. The Timor court had this to say, that an inquest must be so thorough that the public and interested parties are satisfied that there has been a full and fair investigation into the circumstances of the death. My lady, as the court heard the evidence of the family, amongst others, as well as the evidence of the organization that Chief Albert Luthuli led, echoing the fact that they were never satisfied. They were not satisfied of the fact that there was enough and sufficient ventilation of evidence, as well as not being satisfied with the outcome thereof. Again, as we are asking this court whether the court was presented with sufficient evidence to make a credible finding in terms of Section 16 subsection 2 of the Inquest Act. Whether there was sufficient evidence to anchor the finding of a train accident. Or whether there were proven facts, as our law dictates, that a finding, rather a finding based on inferential reasoning, can be made by a court. But the inferential reasoning ought to be based on proven facts. When this court looks at the body of evidence of the initial inquest of 21 September 1967, it has to interrogate whether it had sufficient evidence to draw an inference. My lady, is I am submitting that the questions that we are posing and the questions that we dealt with in leading of evidence, the questions that we had to deal with, seeking authorization, and or reopening of these inquest proceedings. My lady, I want to remind us and ask us to remind ourselves of what these proceedings are, of what an inquest is. My lady, what the Inquest Act says it is is equally found in our jurisprudence in a number of cases. But I will refer this court to few of those. In the case of the freedom under law versus the National Director of Public Prosecutions, the court has this to say about an inquest. An inquest is an investigation.
Citation.
My lady, it's 2014. 2014, just a minute, my lady. I'll find the full citation. Okay, it's 2014 ZA SCA at page 50. The judgment was handed down on the 17th of April, 1914. No, not 1914, 2014, my lady. My lady, those that are born in the 19s will always refer to their era. And that explains or tells their ages. Yes. My lady, I'm saying, in this letter, the court had this to say about an inquest. I quote, "An inquest is an investigatory process held in terms of the Inquest Act, which is directed primarily at establishing a cause of death where a person is suspected to have died of other than natural causes." Section 16, subsection 2 of the Inquest Act requires a magistrate conducting an inquest to investigate and record his findings as to the identity of the deceased person, the date, and cause or likely cause of his death, and whether the death was brought about by any act or omission that prima facie amounts to an offense on the part of any person. The court went further to say the presiding officer is not called on to make a determinative finding as to culpability. My lady, bearing in mind the object of an inquest, I can only submit that the test that is employed during inquest proceedings is not that of beyond reasonable doubt. It is a less stringent rule. A less stringent test, my lady, should be based equally on facts and evidence, and it has to show if there is prima facie evidence that points to the fact that needs to be determined, including a determination whether there is a person to be held responsible for the death of the deceased.
Mr. Pina, you just let's go back to your reference to the test that is applicable. That is applicable or not applicable. You say
My
it's
lady-
not beyond reasonable doubt. What would your submission be on the other test of the balance of probability?
My lady, the balance of probabilities does apply. It is a less stringent test than beyond reasonable doubt.
I'm trying to think of the balance of probabilities with service the establishment of the prima facie case.
My lady, when one looks,
Even less than the balance of probabilities.
the prima facie is even less. That is why even the case law says in our jurisprudence that that is the threshold, that is the test. My lady, I'll refer your ladyship to such a case where may the court bear with me for a second. My lady, I found in the both in the matter of the inquest into the life at Esidimeni, that inquest is inquest number 1001/21 brackets 2024 ZAG capital PPHC at page 667, handed down on the 10th of July 2024. My lady, on the test to be employed during inquest proceedings, the court had this to say: bearing in mind the object of an inquest, it is my opinion that the test to be applied is not the reasonable doubt test, but something less stringent. In my opinion, the test envisaged by the Inquest Act is whether the judicial officer holding the inquest is of the opinion that there is evidence which may, at a subsequent criminal trial, be held to be credible and acceptable, and which, if acceptable, could prove that the death of the deceased was brought about by any act or omission which involves or amounts to the commission of a criminal offense on the part of some person or persons. Therefore, the court in that inquest found that the beyond reasonable doubt test can find no application My lady, as I have indicated, the purpose of an inquest and what is expected of an inquest court is contained in a litany of our jurisprudence. In the Timol case, Timol and another, this is the magistrate Johannesburg and another 1972 subsection, rather 1972 in brackets 2 SA 281 in brackets T at 287 capital H to 288 capital A. The appellate division observed that for the administration of justice to be complete and to instill confidence, it is necessary that, amongst other things, there should be an official investigation in every case where a person has died of unnatural causes.
Sorry, Mr. Junior, the page, the second page.
Page is 287 capital H to 288 capital A. That's what please. My lady, the court was looking at putting it explicitly what the inquest proceedings are to be and when they are to be held, when there has been an unnatural cause of death, as the case was and is in our proceedings. We're looking at the death of Chief Albert Luthuli, which was unnatural. And the court then, as it was then and is now, enjoined into conducting a judicial investigation into his death. My lady, in the matter of Tilly versus Additional Magistrate Cape Town, which is the 1988 volume 4 SA at page 769, capital C at page 775, capital G. It was said, an inquest is not aimed at proving anyone's guilt, but it is most certainly aimed at ensuring that, if possible, where guilt exists, it will not remain hidden. My lady, we deal with this aspect of an inquest and its purpose in our heads, and I do not intend to over elaborate on it, save to say and submit that the court, when looking at the provisions of the Inquest Act, as well as the jurisprudence referred to, it has to ask itself whether the initial inquest court did discharge the duty it was enjoined to deliver on or not. A duty to ensure that a proper investigation, a full investigation into the death of Chief Albert Luthuli was done or not. Whether that inquest court conducted a fair investigation that would be acceptable not only to the family of Chief Albert Luthuli, but also to the peoples of South Africa and those of his organization. My lady, without again overstretching the points and or submissions made in our heads of argument, I want the court to take notice of the fact that in our heads, in trying to find evidence or align the finding of the 1967 Inquest Court to evidence, we had to look at the two cardinal rules of logic as referred to by Watermeyer J.A. in Arvis of Blom, 1939 AD, at page 188. More particularly at page 202 to 203, where the court said that proven facts should be such that they exclude every reasonable inference from them, save the one to be drawn. If they do not exclude other reasonable inferences, then there must be a doubt whether the inference sought to be drawn is correct. We went down this road in trying to find what could possibly have enabled Magistrate Bozen at the initial inquest to find as he did. What could have enabled him to find that Chief Albert Luthuli died as a consequence of a train accident? Were the injuries that he had sustained consistent with a train accident? Then, my lady, at the time, in 1967, there was no scientific evidence presented that spoke to the nature of the injuries, that spoke to an accident train and what it could do and not do. My colleague, Ms. Chwene, will deal more with the said inquest of 1967. I was just giving a helicopter view of the arguments to be presented by my colleague. My lady, we will argue and make submissions that the treatment that was meted out to Chief Albert Luthuli, as Dr. Ntsele has testified, was below standard. And those medical practitioners that came into contact with him could have done more if it were not for segregation policies. My lady, whether the segregation policies as they existed then meant that the life of those that were considered enemies of the state was of lesser value. Whether the acts of the medical practitioners were not amounting to an assist of an event that was desired, an event of the death of Chief Albert Luthuli. But I am saying this because you will find again in our heads, we were saying to this court, when one looks at one of the key medical practitioners who attended to Chief Albert Luthuli, that being Dr. Jacobus James Fanze, who was a medical practitioner, district surgeon, who later on became the mayor of Stenga. This might call into question whether professionals in the employ of the state were apolitical or not. Whether medical practitioners, district surgeons, were part of a system to fight those considered as enemies of the state. Mr. Msimango will dig deep into that so that we might be wiser than we were of the role that was played by the civil servants in ensuring that apartheid is implemented and is to achieve the desired objectives. Yes, my lady, as I'm about to hand over to my colleagues, I wish to concede that, like in the inquest of Timor, like in the inquest of Hafeji, like in many more inquests that are still pending before our courts, families, the peoples of this country had to wait. Part of the reasons why is, as this court has heard, the testimonies of the investigating officers, starting from Captain Khamanyane, Colonel Monte, Lieutenant Captain Stein, that documents have been destroyed. Evidence has been destroyed. And more effort at a great loss of time has to be put into investigations. My lady, one would hope that evidence and or documents that deals with deaths in detentions would be easier to be found than any investigation. That is why the lives of Mr. Lapaskachn are commended for providing their resources in this matter, for them availing their locomotives to be a subject of these proceedings. That is why the lives of Warrant Officer Burgess and Sunel are acknowledged for the reconstruction of the scene. My lady, if the court, can I request that the court takes an early adjournment into lunch, and after lunch, Ms. Trene will take over from me.
Thank you. At this point in time, are you done now? So Ms. Trene will commence after lunch.
My lady, Ms. Trene will commence after lunch.
Thank you. We'll take the lunch adjournment with resume progress.
particularly just, for us to know.
So it will allow your address such that we attend the participant to
As a participant, my address is quite lengthy, but I have to speak with the judge and the last continue tomorrow. Thank you. My lady, I would like to start off with reading case law in respect to the duties of a prosecutor. And I shall explain at a later stage why it is that I am reading this case law. My lady, in Art versus Dubok, it's a 1914 decision, EDL 348 at paragraph 354,
Can I get that citation again?
Art versus de Kock. It's a 1914 decision.
1914.
Correct, my lady. EDL 348 at 354. The court held as follows. The Crown prosecutor should have no other interest in the case than to lay before the court such facts as may assist the court in arriving at the truth. This is his sole and only duty. The next case is R versus Rickert. It's a 1954 decision, volume 4, SA 254, in brackets, SWA at 261F. The court held as follows. The public prosecutor does not only represent the interest of the Crown, but he also has a duty towards the accused to see that an innocent person be not convicted. Thus, it is his duty to disclose, in certain circumstances, facts harmful to his own case. The next decision is S versus, I'll spell it out, my lady, TAKAENDESA. I'm not sure of the pronunciation.
Yes.
And it is a 1972 decision, volume 4, SA 72, in brackets, RAD at 74 F to G. The court held as follows. If the prosecutor had been aware of the true facts and concealed them from the court, he would have been guilty of a gross dereliction of duty and one that could only be strongly condemned. And the last case, my lady, is S versus Chokugudza. I think it's Chokugudza. It's CHOGUGUDZA. It is a 1996 decision, volume 1, SACR 477, in brackets ZS at 487H. The court held as follows. Prosecutors are placed in positions of authority. It is their duty to ensure that accused persons are dealt with properly and in accordance with the law. As officers of the court, their bounden obligation is to uphold the law and by their conduct set an example of impeccable honesty and integrity. A failure to do so will lead to an erosion of confidence in the minds of the public. My lady, I quote these cases in the recognition that myself and my colleagues, in the various aspects that we are going to place before the court, will be criticizing various state departments. And I do realize that as a state employee, perhaps it is frowned upon to do so. But I highlight, my lord, that it is our duty as prosecutors to assist the court to come to a just verdict. We therefore felt it pertinent, my lady, to provide an analysis of technical evidence presented at the initial inquest, which was held on the 19th of September 1967, and the current reopened inquest, which commenced on 14 April 2025, in order to assist this court at arriving at a just verdict, as it is our duty to do so. Through this analysis and other points which will be raised by my colleagues, we seek to influence this honorable court to overturn the ruling of the inquest court handed down in 1967 in respect of the death of Chief Albert John Luthuli. We submit that the overturning of the ruling would amount to a just verdict with respect to the circumstances which led to the death of the deceased. My lady, to do this, we map out the evidence which was provided by trained experts, reconstruction and simulation experts, as well as the medical experts during these current reopened proceedings, and juxtapose this evidence against all evidence presented at the initial inquest in 1967. We do this as an indication to your ladyship the web of lies which was spun by witnesses and persons in authority in respect of the 1967 inquest, as well as the extent and measures which were taken to cover up circumstances leading to the death of the deceased. At the initial inquest of 19 September 1967, the proceedings commenced with oral testimony from 2 medical practitioners, followed by the testimony of the investigating officer, the testimony of a laborer from the South African Railways, as well as testimony from the occupants of the locomotive which allegedly struck the deceased. Other evidence brought...
I think you must lower your pace.
Should I go slowly?
Yes.
Okay, I have
Not too slow.
not too slow, but not too fast. Just
Yes. Try and make it the speed of one.
I will attempt to do so. Thank you, my lady. Other evidence brought before the court was in the form of written affidavits from various witnesses. For context, we provide a summary of evidence presented by each witness at the inquest proceedings of 1967, and later we outline key aspects arising from expert evidence which was presented in the current reopened inquest proceedings. Evidence from medical practitioners at the 1967 inquest proceedings. The following medical practitioners were called upon to provide oral testimony at the initial inquest. Number 1, Dr. Gwendolyn Mary Bregson, who was a registered medical practitioner and a senior superintendent of Stanger Hospital. Her written affidavit was also read and submitted as Exhibit A during the said proceedings. Number 2 was Dr. Jacobus Johannes van Zyl, who was a registered medical practitioner and district surgeon for Stanger District. He compiled a post-mortem report in respect of the deceased, which was read and submitted as Exhibit C in the said proceedings. The other doctor, Dr. Mauritius Johannes Hubert, a neurosurgeon from Durban, who is said to have made medical findings in respect of the deceased, was not called to testify. However, his affidavit was submitted as Exhibit B in the said proceedings. For ease of reference, my lady, the inquest record of 1967 was marked as Exhibit D, which was Volume B. Evidence from the police at the 1967 inquest proceedings. Detective Sergeant Charles Barend Petrus Lewis from the South African Rail Police in Durban gave oral evidence at the initial inquest. He presented himself as the investigating officer of the case. During the proceedings, the record indicates that his written statement was read, handed in, and marked as Exhibit D in the said proceedings. Other documents which he compiled were also handed in. That was a plan marked as Exhibit E, a key to plan marked as Exhibit F, and photographs which were marked as Exhibit G. It is submitted that the evidence of this witness is of a technical nature because he recorded a key to plan wherein he recorded several measurements in respect of the incident, the details of which shall be analyzed at a later stage of this address. Another statement by one Andries Pietermaritzburg from the Stanger Railway Police was also submitted as Exhibit P in the same proceedings. However, it is submitted that his evidence is not of a technical nature, but will at a later stage, and for the sake of completeness, be summarized and analyzed. Evidence from the locomotive driver at the 1967 inquest proceedings. The driver of the train is said to have been Stephanus Albertus Lategan. In an affidavit, he provided details with respect to the locomotive type, dimensions of the locomotive, its load and tonnage, as well as the speed at which the locomotive was traveling when it allegedly struck the deceased. Other versions presented by witnesses at the 1967 inquest proceedings. My lady, we submit that technical evidence of witnesses cannot be analyzed in isolation without considering the versions which were presented by other witnesses who either submitted statements or oral evidence in respect of the incident at the initial 1967 inquest. It is also important to note any possible circumstantial evidence. In that respect, my lady, the evidence of the following witnesses will also be analyzed. Number one, Daniel Nessing Freylen, who was a fireman on board the locomotive. Number two, Peter Francois van Veek, who was the conductor on board the locomotive. Andries Ludovicus Helhemus Pretorius, who was the station master of Glenhow train station. Number four, Nzakani Matara, who was a laborer employed by the South African Railways Administration. Number five, Peter Francis Papaya, who was the ambulance driver for Stanger Hospital. Number six, Andries Pietermaritzburg, who was a detective sergeant of the South African Railway Police stationed at Stanger. Number seven, Eric Tembinkosi Chili, who was a bus rank manager. Number eight, Nobukhanya Luthuli, who was the wife of the deceased. Number nine, Enes Mfeka, who was an employee of the deceased General Dealer Store in Groutville. And number 10, Zipi Kumede, who was employed by the deceased to work at his sugarcane plantation. We proceed to present a summary of the evidence presented by each witness at the 1967 inquest proceedings. Summary of evidence and injuries observed by Dr. Gwendolyn Mary Gregerson. Her evidence, my lady, or her statement is on page 465 to 466 of Exhibit D. When Dr. Gregerson attended to the deceased, who was still alive upon admission at the hospital, she noted certain injuries on the head and body, as well as regions from which there was bleeding. The injuries which she noted on the head are as follows. Fracture on the base of the skull. She stated that the bleeding of the ear suggested a fracture at the base of the skull. Number two, a jagged laceration at the base of the skull on the left-hand side, which was about 4 to 5 inches long, that is approximately 12 centimeters long. Number three, a 3-inch, approximately 7 centimeters long, laceration on the center of the occiput. Number four, an abrasion on the right parietal region. And number five, a laceration of an inch, which is approximately 2.5 centimeters long, on the same right parietal region. The injuries which she noted on the body of the deceased was fractured ribs on both sides, a fractured left elbow, a fractured left hand, and a laceration on the right lower leg. However, the length of the laceration was not provided. And the summary of the bleeding which she observed: number 1 was bleeding from the right ear, and number 2 was bleeding from head injuries. Dr. Gregerson also noted the condition of the clothing, and she stated that it was torn and dirty. Medical journals define a fracture as a break or crack in the bone, whilst a laceration is defined as a wound caused by a tear or cut in the skin or other soft tissue. Abrasions are defined as a type of open wound caused by the skin rubbing against a rough surface. Therefore, my lady, according to Dr. Gregerson, the total injuries on the head which she observed were 3 lacerations and 1 skull fracture at the base. On the body, she noticed fractures on both sides of the rib and 2 fractures on the left upper limb, namely the hand and elbow. There was 1 laceration on the right lower leg. According to Dr. Gregerson, there were no signs of the body having been dragged. Medical treatment that was given to the patient included transfusion and oxygen. The patient was also given a cardiac stimulant, and his wounds were sutured, that means stitched. X-rays were also taken from the patient. Dr. Gregerson stated that she attended to the patient at 11:30 a.m. in the morning on 21 July 1967, and that the patient died on the same day at 2:25 p.m., which was 5 minutes after a neurosurgeon from Durban, Dr. Hubert, had arrived to see the patient. Dr. Hubert saw the patient at 2:20 p.m., according to the statement of Dr. Gregerson. A post-mortem examination was conducted on the deceased on the same day he died, although it is not apparent from the statement of Dr. Gregerson as to what time this examination was done. She confirmed that she was present when the said post-mortem examination was conducted by Dr. J.J. van Zyl, whom she described as the district surgeon of Stanger, and that she identified the body to van Zyl as that of Chief Luthuli. On 24 July 1967, she was at Stanger Mortuary, where a second identification of the body of the deceased was done by Mr. S.A. Latagan, whom she described as the driver of the train that struck the deceased on the morning of 21 July 1967. Summary of evidence and injuries that were observed by Dr. Jacobus Johannes van Zyl. His statement is on pages 468 to 471 of Exhibit D, my lady. He states that on 21 July 1967 at 4 p.m., he conducted a post-mortem examination on the body of Chief Luthuli. He testified that the deceased sustained multiple injuries, which were caused by him being struck with a very heavy object. He further testified that he noted 2 lacerations on the head, 1 on top and 1 at the back. Dr. van Zyl noted the following injuries on the deceased's head. Number 1, fracture of the base of the skull based on blood oozing from the right ear. Number 2, multiple lacerations on the skull, which were sutured. However, there's no mention of exactly how many of these lacerations were present. Neither is there a mention of how deep or what the lengths of these lacerations were. Dr. van Zyl noted the following injuries on the body. Number 1, fracture of both the left and right ribs, fracture of the ulnar end. Number 3, multiple bruises on the left and right hand dorsal aspect. Number 4, laceration on the right shin. Number 5, puncture mark on the right cubital vein caused by an IV drip. Dr. Van Zyl further noted on his report that the body appeared to be that of a 70-year-old Bantu male whose height was 5 foot and 10 inches, that is approximately 177.8 centimeters, and weighed approximately 170 pounds, that is approximately 77 kilograms. The death occurred approximately 1.5 hours prior to the examination, and the cause of death was cerebral hemorrhage and contusion brain. The body was identified as being that of Albert John Luthuli by one Eric Trilly, Peter Papaya, and Dr. Gregerson. The observations that were made by Dr. Mauritius J. Hubert. Dr. Hubert did not testify, but submitted an affidavit describing himself as a neurosurgeon from Durban who, on 21 July 1967, was summoned by Dr. Gregerson to attend to Albert Luthuli. At this stage, we would like to point out that it is curious as to why Dr. Gregerson decided to summon the neurosurgeon from Durban, who arrived close to 2 hours and 15 minutes later, if we are to work with the admission time of 11:30 a.m. as she had stated. It is clear that Chief Luthuli was in need of specialist neurological care. Therefore, it is curious as to why he was not immediately transferred to King Edward Hospital in Durban, which is said to have had the best facilities to cater for critical patients. Dr. Hubert did not state as to what time he arrived at Stanger Hospital and at what time he examined the deceased. It is submitted that...
Sorry, his affidavit is...
Oh, it is on page 467. Apologies, my lady.
Which was
467. It is submitted that this was a deliberate omission on the part
just
of...
one page.
Just one page, my lady.
Yes.
Thank you. It is submitted that this was a deliberate omission on the part of Hubert. He did this in order not to expose his negligence for not attending to the deceased timeously. Arguments shall be advanced at a later stage to indicate that the admission time for Chief Luthuli at Stanger Hospital was around 12:40 and not 11:30, as stated by Gregerson. We submit that...
Sorry, the admission time?
Admission time, according to
Dr. Hubert's affidavit,
Dr. Hubert does not
does
mention
not mention
the admission time. The admission time was mentioned by Dr. Gregerson, stating it to be 11:30 a.m.
And where do you say there is a discrepancy?
My lady, we are saying that at a later stage, we shall advance arguments to indicate why we say that he was admitted at 12:40 and not 11:30. At a later stage, we shall...
Which is more than an
Which
hour
is more.
and 10 minutes.
Correct. We submit that even with this added advantage of time, it is curious why it took Dr. Hubert 1 hour and 45 minutes to travel to Stanger Hospital, which is approximately an hour away from Durban. Dr. Hubert arrived at Stanger Hospital at 14:25. It is curious why it took him an extra 45 minutes to the hospital. Dr. Hubert noted the following with respect to the deceased. Number one, he was in a...
Sorry, Ms. Chairman, that will obviously become very important.
Correct, my
So
lady.
the arrival time.
Correct, my lady.
You say he arrived in Stanger town.
At Stanger Hospital.
At what time?
It is stated by Dr. Gregerson that he arrived at 14:20.
But Dr. Hubert himself doesn't state.
No, my lady, he does not state. Dr. Hubert noted the following with respect to the deceased. Number one, he was in a deep coma. Number two, he was not responding to any form of stimulation. Number three, his pulse was feeble and his blood pressure could not be recorded. Number four, his breathing was shallow and irregular. Number five, his conjunctivi were very pale. Number six, His left pupil was obliterated by a chronic scar and cataract. Number 7, his reflexes were absent.
Why do you, it's.
These are the observations that
It says
he made.
his pupil was obliterated by a chronic scar,
And cataract.
and there was a dense cataract in the left eye.
Correct, my lady. And further, he noted that the reflexes of the deceased were absent. Dr. Hubert observed X-rays which were conducted on the deceased and noted the following. Number 1, extensive skull fractures. However, there is no mention of the number of fractures and their extent. Number 2, fracture of the left elbow. Number 3, fracture of the right ninth rib. He further stated that it was not possible to ascertain whether there was an associated hemothorax or peritoneal hematomia. He further stated that besides supportive measures having been instituted, the patient demised. He, however, did not state the type of supportive measures which was instituted, and neither did he record the time of death. According to medical journals, hemothorax or peritoneal hematomia is defined as a collection of blood in the pleural cavity, most commonly occurring following chest trauma. Based on the statements of the 3 medical practitioners, we submit that a number of discrepancies can be highlighted. Firstly, Dr. Yuk observed the fractures on an X-ray, noted only one injury on the right rib, namely the ninth rib, whilst both Dr. Gregerson and Dr. Van Zyl stated that both ribs of the deceased were fractured. They do not, however, elaborate on the extent of the injuries and how it is that they were able to observe these fractures. Secondly, Dr. Hubert does not make mention of any lacerations on the head of the deceased, whilst Dr. Gregerson makes mention of 3 lacerations, and Dr. Van Zyl refers to multiple lacerations without indicating an exact number. Thirdly, Dr. Hubert does not personally mention the fracture, does not specifically mention the fracture of the base skull. He only refers to multiple fractures. Both Dr. Van Zyl and Dr. Gregerson concluded that the deceased had a fracture on the base of the skull because he was bleeding from the right ear. None of these observations were made by Dr. Hubert, including bleeding from the right ear. We pause to mention that as a neurosurgeon who is a specialist when it comes to skull injuries, this fracture at the base of the skull should have been noted by Dr. Hubert. At the very least, the bleeding from the right ear. We are left wondering why this injury was not noted by Dr. Hubert, to the extent of wondering whether this fracture was indeed present. Fourthly, Dr. Gregerson said that the deceased's left hand was fractured, but that aspect was neither noted by Dr. Van Zyl nor Dr. Hubert. She also mentioned an abrasion on the right parietal region, which was not noted by either Dr. Van Zyl nor Dr. Hubert. Both Dr. Van Zyl and Dr. Gregerson noted a laceration on the lower right leg of the deceased, but this aspect was not noted by Dr. Hubert. Number 6, on the record, Dr. Gregerson noted bruising, although it is not clear where she saw the bruising. Dr. Van Zyl noted bruising on the dorsal part of each hand. This aspect was not noted by Dr. Hubert. Number 7, the clinical observations made by Dr. Hubert were not noted by Dr. Gregerson, and it is not clear whether she was present when Dr. Hubert examined the patient. The only injury which all 3 doctors noted without contradiction is the fracture of the left elbow, although Dr. Van Zyl referred to it as a fracture to the ulnar proximal end. We pause at this stage to submit that it is curious as to why Dr. Hubert, who was the last person to have seen the deceased alive, was never called to testify, and to place on record the exact measures he undertook to save the life of the deceased. We are informed that he was especially called to attend to the deceased based on what can only be assumed were his specialized skills. However, we are none the wiser as to whether he even bothered to administer those skills onto the deceased. We now move on to the evidence of the police personnel. As stated earlier, 2 policemen submitted written affidavits. Detective Sergeant Charles Barent Petrus Lewis, whom we shall refer to as Lewis, and Andries Paul Berger, whom we shall refer to as Berger. Only Lewis was summoned to testify at the 1967 inquest, and we proceed to present a summary of evidence of both policemen. The summary of evidence of Detective Sergeant Charles Barent Petrus Lewis. My lady, his statement is on pages 472 to 473 of Exhibit D. He testified that he started investigating the matter on 22 July 1967. He read his statement into the record, which was then submitted as Exhibit D. According to his statement, both he and Detective Sergeant A.P. Berger of the South African Railway Police went to the scene of the accident on the Umvoti River Bridge with the locomotive driver S.A. Lattegan, whom we shall refer to as Lattegan, on 24 July 1967. Lattegan and Berger pointed out to Lewis where the deceased lay after the alleged incident. Lattegan further pointed out where the front of the locomotive engine was when the deceased entered the bridge, as well as where the rear of the van attached to the locomotive came to a stop after the accident. Lattegan informed him that the rear of the van stopped at the 46.5 miles mileage board. He noted down measurements between various points, which he illustrated on a sketch plan as well as a key to the sketch plan. He stated that the bridge was a straight bridge which measured 963 feet, that is approximately 293.5 meters long, with no obstructing structures. He stated that there were people working on the construction of a new bridge to the west, which was about 100 yards, that's approximately 91 meters away from the scene. However, none of them saw the alleged accident. Further investigations indicated that the deceased left his store at 10 a.m. in the morning, stating that he was headed to his sugarcane plantation. However, he never arrived at the said plantation. He was informed by Lattegan that the alleged accident occurred around 10:38 a.m. when the deceased was walking towards the approaching locomotive on the bridge. Lewis concluded that there was no evidence to show any negligence on the part of any of the staff on board the locomotive. During his oral testimony, Lewis indicated that when the train crosses the bridge, the engine overlaps the steel footplate, which is often used by pedestrians, by 10 to 10.5 inches, that is approximately 26 centimeters. He was further asked to comment on a newspaper photograph which appeared in the Sunday Tribune on 30 July 1967. Lewis confirmed that the picture was an indication of how the engine of the said locomotive overlaps the footpath, although he could not confirm if the engine depicted thereon was the same as the one which was involved in the accident.
That in reference to the subsequent pages, his statement, his affidavit ends, which was submitted here as Chief.
His affidavit ends on 473.
And thereafter, we have a sketch plan that is incomplete. And then, so now, with reference to which aspect are you now making submissions?
I'm just summarizing his evidence, my lord, both written and oral. There's oral evidence. I just have to find the exact location of the oral evidence, my lady. I apologize for that. If I may come back to that at a later stage,
Yes, thank
I'll indicate to the court where it appears. So his oral testimony, he indicated that when the train crosses the bridge, the engine overlaps the steel footplate, which is often used by pedestrians, by 10 to 10.5 inches, which is approximately 26 centimeters. He was further asked to comment on a newspaper photograph which appeared in the Sunday Tribune on 30 July 1967. Lewis confirmed that the picture was an indication of how the engine of the said locomotive overlaps the footpath, although he could not confirm if the engine depicted thereon was the same as the one which was involved in the accident. My lady, we pause to submit that this is an indication that Lewis never made any efforts to ascertain the whereabouts of the train. He was essentially the investigator of a train accident for which the alleged train involved was unknown to him. This, as it shall be pointed out later, points to an indifference on the part of the police to thoroughly investigate the matter. Lewis was not able to confirm how long the train was, and we again pause to submit that this, once again, is proof that Lewis had never seen the train, which was said to be involved in the accident, nor did he bother to trace it. Lewis did, however, establish through the train staff that the train hauled 60 axles and weighed over 700 tons. He further established that the train was traveling from south to north. We now move to summarize the evidence of the other police official, which is Sergeant Andries Pietermaritzburg. His statement, my lady, is on page 494 to 495 of Exhibit D. On 21 July 1967, he was on duty at South African Railways Stanger Station when he says that he received a call from one Steyn, who was the station foreman of Gledhow Station. The call came through at 10:55 a.m., informing him of an accident which occurred at Umgoti River Bridge involving a train and a Bantu man. The station foreman further informed him that the Bantu man was struck by the train, that the Bantu man who was struck by the train was ex-Chief Albert Luthuli. On his way to the accident scene, he states that he met an ambulance en route to Stanger Hospital, driven by P.F. Papaya. He further states that he and someone else, whom he does not mention by name, were informed by the said ambulance driver that ex-Chief Luthuli was being transported to the hospital. It is not clear how the ambulance driver informed him of this fact. It can only be inferred that Berger stopped the ambulance and inquired about the patient on board. Berger then proceeded to the accident scene and arrived there at 11:20 a.m. We pause to submit at this stage that it is curious why Berger would stop an emergency vehicle. It is also curious how he knew who the ambulance driver was, unless he stopped the ambulance and inquired from the driver what his name was. However, this too is quite strange, because surely what was at stake was the life of an injured man, not to make conversation about such man. One can only wonder how long the conversation between Berger and Papaya took. Berger states that upon his arrival at the accident scene, he met the station master who pointed out the place where the head of the deceased allegedly was. He was also told that the deceased's head was next to the rail where there was a large pool of blood. It is not clear who at the accident scene informed him of this. It can only be assumed that it was the station master who informed him. He was also shown a steel plate upon which the body of the deceased was placed until the arrival of the ambulance. Later the same day, he states that he was informed, although he does not mention by whom, that ex-Chief Luthuli had died in hospital. He stated that he made marks at the scene of the accident with respect to where the deceased was found after the alleged accident, as well as the point where he found blood. We pause to submit that it is curious as to why he would point out where the deceased was found when, according to his own statement, he arrived at the scene after the deceased had already been transported by the ambulance to the hospital. It is expected that such pointing out would have been made by the station master. Berger further stated that the train had already departed, but he was able to establish that the train driver was S.A. Luthuli, who was together with fireman Freyland and guard P.F. van Veed. He stated that he could not locate anyone who witnessed the accident. On 24 July 1967, Berger went to the scene with Lewis and pointed out the points which he had marked on 21 July 1967. We pause to submit that it is curious why the station master, Van Veed, Freyland, and the station foreman Steen were not present to make the pointings, in light of the fact that these were the people who were present at the scene. We now move to highlight improbabilities, inconsistencies, and aspects of gross negligence inherent to the statements of Lewis and Berger. An analysis of evidence presented by Lewis points to a glaring omission with respect to the manner in which the investigations were conducted in this matter, especially regarding the locomotive. Firstly, there is no indication whether the station master was interrogated with respect to the reasons behind the train driver and his staff having left the accident scene before the arrival of the ambulance and police. Secondly, there is no indication whether any efforts were made by Lewis to trace the locomotive, which is said to have been involved in the accident, or whether any investigations were done to check if any forensic evidence could be obtained therefrom. Further, no questions were posed to Luthuli and Freyland as to why they risked further possible injury to the deceased by moving him before the arrival of the ambulance. There is no indication of whether or not the scene was cordoned off on 21 July 1967 to preserve it for purposes of collecting evidence. Official investigations relating to the scene were only done on 24 July 1967, that is 3 days after the event. There is also no indication that the bridge was closed off by the South African Railway between 21 and 24 July 1967. Therefore, the probability of the scene having been contaminated during that period is very high. The likelihood of forensic evidence being present at the scene on 24 July 1967 was close to no. As was evident during these reopened inquest proceedings, the scene was contaminated, albeit not intentionally, by persons such as Elliot Mumalo and his brother-in-law Babaso when they went to clean the blood of the deceased. Clearly, the scene was never cordoned off. There is no indication that an investigation into the track conditions was ever done, nor of the train which was alleged to have been involved in the incident. This information would have been crucial in assisting the court to determine a possible cause of the alleged accident and identifying potential contributing factors such as mechanical failures, human error, or environmental conditions. It is submitted that accident scene preservation by the police is important for purposes of ensuring accurate evidence collection. Maintaining the integrity of the accident site allows for proper analysis of physical evidence, witness testimonies, and potential contributing factors. This meticulous approach is vital for establishing liability and potentially preventing similar accidents in future. No proper accident reports were compiled by either the South African Railways or the police in order to provide detailed accounts of the accident. No efforts were made to trace the train to ascertain whether there was any damage thereto, and the only photographs that were taken by Lewis was on 24 July 1967. No photographs were taken by Berger on 21 July 1967 as the first policeman on site. The absence of photos of the scene from 21 July 1967 therefore resulted in a situation where it was not possible to ascertain the impact of the alleged accident. It begs the question, therefore, how it is that the Inquest Court in 1967 could have come to any conclusion pertaining to the death of the deceased, when the inquest was littered with such glaring investigative omissions and or gross negligence on the part of the police. We submit, however, as it will be elaborated on later, that none of these crucial investigative steps were embarked upon by the police because there was no train accident which occurred on the Umvoti River Bridge on 21 July 1967. Aspects relating to the measurements taken by Lewis can only be analyzed in conjunction with independent reconstruction evidence. Such evidence was provided in the current reopened inquest proceedings by Warrant Officer Brendan Craig Burgess of Crime Scene Management in Pretoria. His evidence will be outlined and juxtaposed against that of Lewis at a later stage during this address. The eyewitness accounts. According to evidence presented at the 1967 inquest, the only person who claimed to have seen what happened to the deceased is the driver of the locomotive, Stephanus Albertus Lattergan. Two other persons who were on board with him on the locomotive, Daniel Lessing-Grelen and Peter Francois van Beek, stated that they did not see how the train struck the deceased. They did, however, submit statements and testified to their experiences on board the locomotive when it was crossing the Umvoti Bridge, as well as when it stopped just after the bridge.
So in other words, they testified only about generally,
Correct, my lady.
instead of being specific to this particular so-called accident.
Correct, my lady. For the sake of completeness and for cross-referencing at a later stage, we move to summarize the evidence of those who were on board the train. The train driver, Stephanus Albertus Lattergan, fireman, Daniel Lessing-Grelen, and the conductor or guard, Peter Francois van Beek. The summary of the evidence of the locomotive driver, my lady, his statement is on pages 504 to 506 of Exhibit D. In his affidavit, he stated that on 21 July 1967, he was the driver of a Class 15CA locomotive with model number 2045 and train number 332, which departed from Stanger at 10.
Sorry, is it exhibit?
It's Exhibit
or,
D.
Or volume D?
It's Exhibit D, Volume B. B for baby. Thank you, my lady.
Yes, page 504.
Page 504 to
Which is
506.
exhibit D
Correct, my lady.
for our records.
For our records. Thank you, my lady.
Yes.
He stated that the train departed from Stanger at 10:29 a.m. It was a goods train with 60 axles and weighed 767 tons. Whilst his train was passing over the Umvoti Bridge, which was about 60 yards, that is approximately 55 meters, from the southern end of the bridge, he saw the deceased enter the bridge and started walking on the narrow steel plate. Lattergan stated that when he first saw the deceased, he was wearing a khaki-colored overcoat, and he sounded the whistle of the train when he saw the deceased enter the bridge. Lattergan further stated that the deceased walked facing the oncoming train, and after he had walked about 15 to 16 paces, that is approximately 12 meters, the train then struck him. According to Lattergan, the deceased was struck by the corner of the cab on his right shoulder, which caused the deceased to spin around, lose balance, and fall between the right-hand side of the bridge and the moving train. This is when, according to Lattergan, he immediately applied the brakes of the locomotive. He stated that he could not have applied the brakes in time to avoid a collision, and even if he had done so, because the deceased did not turn his body sideways, it was inevitable that the train would have struck him. Upon stopping the locomotive, Lattergan stated that he noticed that the guard van, that is the rear cabin of the locomotive, was about 10 feet, that is about 3 meters, away from the end of the bridge. At the time of the incident, his train was traveling at about 25 miles per hour, that is approximately 40 kilometers per hour. Upon stopping the train driver ran back to where the deceased was lying. At that stage, the deceased was unconscious, according to Luthuli. He found that the guard, that is Van Beek, was present with the deceased. He states that, and I highlight this as important because we shall deal with this aspect at a later stage. He stated that the deceased was lying on his back. This is the position that he found the deceased. Lying on his back with his head hanging between the side of the rail and sleepers, and one arm also hanging over a sleeper. He says that the deceased or the injured person had a big laceration on the top of his head in the middle. The train driver stated that he lifted the head of the deceased and placed his body onto the steel plate. According to the train driver, the station master then arrived on the scene and identified the deceased as Chief Albert Luthuli. The station master then told the train driver to depart the scene and that he would remain behind until the arrival of an ambulance. The train driver stated that the delay time between the collision and the departure of the train was 40 minutes. As the train departed, the train driver says that he saw an ambulance arrive. He later heard over the wireless, which nowadays is referred to as the radio, that Luthuli had died at Stanger Hospital. On 24 July 1967, Luthuli identified the body of the deceased at Stanger Mortuary in the presence of Dr. Gregerson and Sergeant Lewis. He further accompanied Lewis to the scene, and at the scene he pointed out the place where the deceased was lying after the collision, as well as the approximate point of where the front end of the locomotive was when the deceased entered the bridge. He stated that the deceased may have used a footpath on the right-hand side of the bridge before he entered the bridge to cross over the Umvoti River. During his testimony, and I will have a look at the page number for you, my lady.
So the statement is?
The statement is 504 to 506. However, there was a point where he gave oral evidence, and I will find the page numbers for my lady. I apologize for that. During his testimony, the train driver stated that he did not have time to slow down and that the deceased was walking in the middle of a footplate which was only 2 feet wide, that is approximately 61 centimeters, and that the side of the engine had knocked down the deceased. Summary of evidence of the locomotive fireman, that is Daniel Lissing Freyland. His statement, my lady, is on pages 483 to 484 of Volume B, Exhibit D.
483 to
484. That's correct, my lady. In his affidavit, Daniel Lissing Freyland, whom we shall refer to as Freyland, confirms that on 21 July 1967, he was on board the Class 15CA locomotive as a fireman or stoker, together with Luthuli, who was the train driver. He further confirmed that the said locomotive left Stanger around 10:30 a.m. He heard Luthuli blow the whistle of the locomotive as the train was crossing the Umvoti River Bridge near the south exit of the said bridge. He stated that whilst the whistle was being blown, he could not see anything in front of the train on his side, which was on the left side of the train, even though he was looking outside his window all the time. We pause to submit a presumption that when he states this, it means that from the time the train left Stanger, he was keeping a constant lookout of his window. He stated that shortly after the whistle had been blown by Lattegan, he, that's Grelen, then saw Lattegan pull the brakes. At this stage, we also pause to highlight that the time interval of shortly is not explained by Grelen. When the train stopped,
Grelen was the fireman.
the fireman, correct.
So he had his, according to his statement, he had been looking out from the time the train was staying up.
He said that he was looking out of his window all the time.
Yes, that's why I'm saying.
And yes, and the presumption that we have is that from the time the train left Stanger,
He was
constantly having a look out of the window.
And his position is behind the driver.
Correct, on the left-hand side.
On the left-hand
Yes,
side.
the driver would have been on the
On the
right-hand side.
right-hand side.
Correct, Manny. Grelen says that when the train stopped, Lattegan informed him that he suspected they had knocked someone over. He and Lattegan then got off the train and walked back to the entrance of the bridge on the south side. This is where he saw the deceased. I'd like to draw my lady's attention to paragraph 4 of Grelen's statement. On that paragraph, Grelen stated that the deceased was clad in a khaki-colored jacket, pants, and a coat. The deceased had sustained head injuries and blood was coming out of his mouth. According to Grelen, the deceased, although unconscious at the time, this is the position that he describes of the deceased. He says he was lying on his back with his head directly on the track and his feet towards the railing side of the bridge. However, my lady, literally the following sentence, there is a contradiction in the description of the position of the deceased by Grelen, where he states that the Bantu lay with his body on the footplate. I'll come back to
He's
this.
contradicting himself.
He's contradicting himself, my lady. He stated that he assisted Lattegan to place the deceased more comfortably on the steel footplate. We submit that in respect of his statement, wherein he stated that the Bantu lay with his body on the footplate, suggests that upon arrival, Grelen saw the deceased on the footplate in an uncomfortable position, and thus he and Lattegan took the decision to place him more comfortably upon the said footplate. Grelen did not make mention of the guard having been on the scene when he and Lattegan arrived. He only mentioned seeing the conductor or guard, that is Van Beek, going towards Glenhouse Station. This is in contrast to Lattegan having stated that upon his arrival at the site where the deceased lay, the train conductor was present. Grelen then stated that shortly afterwards, the station foreman and station master arrived on the scene. Again, the period shortly is not defined in seconds, minutes, or hours. Therefore, it is not clear how long afterwards were they joined by the station master and the station foreman. Further, Grelen did not state as to how long the station foreman and station master were with him in Latterhan at the scene. Grayling stated that he then returned to the locomotive, but was then joined at a later stage by Latterhan, although he does not state how long after he had gone back to the locomotive, Latterhan joined him. Latterhan then informed him that the person who was knocked down was Luthuli, whom he did not know. Grayling was of the opinion that the deceased should have seen the train and heard the tremendous sound that the train normally makes when it moves over a bridge. Further, he stated that it was a clear day and visibility was good. I'll do my best to summarize the evidence of Peter Francois van Wyk in the next 7 minutes, my lady. His statement is on page 487 to 488 of Exhibit D. In an affidavit, Peter Francois van Wyk, whom we shall refer to as Van Wyk, confirmed that on 21 July 1967, he was a conductor on board a locomotive driven by Latterhan. He confirmed that the train 488, I apologize, my lady. 487 to 488.
This is Van Wyk.
Van Wyk.
Van Wyk, old statement 485.
Does my lady have it as 485?
Or is the other translation?
Correct, my lady. Then there's the English version.
Yeah.
Thank you. In an affidavit, Peter Francois van Wyk, whom we shall refer to as Van Wyk, confirmed that on 21 July 1967, he was a conductor on board a locomotive driven by Latterhan. He confirmed that the train was a goods train which consisted of 60 axles and weighed 767 tons. During oral evidence, he stated that the train consisted of 15 wagons carrying sugar and syrup. In his affidavit, he stated that he suddenly felt the brakes of the train being pulled when such train was crossing the Umvoti Bridge. The train stopped just over the bridge with the conductor's car, that's his car, having stopped directly opposite the 46.5-mile marker. During oral evidence, when asked whether the driver of the locomotive blew his whistle, Van Wyk testified that the driver did blow his whistle at the crossing, and just as the last wagon, which was the guard wagon, came onto the bridge. Further in his affidavit, he stated that when he looked back onto the bridge from the window on his right-hand side, this is the position that he saw the deceased, my lady. He saw the deceased lying on the walkway of the bridge. He then alighted the locomotive to protect the train, and whilst doing so, he went past the deceased. He noticed that the deceased was wearing a pair of brown shoes, a khaki shirt, trousers, and a coat. He was not sure whether the deceased was dead or unconscious. He saw blood coming from the mouth of the deceased. He did not mention seeing any other injuries on the deceased. The deceased was lying about 40 feet, that is approximately 12 meters away from the south entrance of the bridge. So according to Van Wyk, my lady, the deceased was on the walkway and not on the train tracks. Van Wyk stated that he protected the train using petards and telephoned the station master and foreman from a telephone box at the Uphace, informing them of the incident. He then went back to where he had placed the petards. After this, he joined the station master and foreman at the scene where they stood for 15 minutes. The station foreman then left to go to the station. Upon his return, it is not clear after how long, the station foreman informed Van Wyk, that is the guard, that the man who was hit by the train appeared to be a certain Luthuli. We pause to submit that this suggests that when the station foreman saw the deceased for the first time, this is stated, he did not know who the deceased was. Van Wyk only became aware of the identity of the deceased when the station foreman returned to the scene for a second time. The question begs, who then at the station informed the station foreman about the identity of the deceased? We submit, as was shown in these reopened inquest proceedings, Chief Luthuli was under constant surveillance. It is therefore submitted that the station foreman was informed by state agents who were constantly watching Chief Luthuli. These people were on a constant lookout for every move made by the deceased, and therefore we submit that they knew exactly what happened to Chief Luthuli on 21 July 1967. The question begs, if the death of Luthuli was not a cover-up by the then apartheid government, why is it that those who were tasked with keeping a constant eye on him did not come forward with versions of what they saw happen to Chief Luthuli?
I don't quite get your submission.
What I'm saying, my lady, is that in these reopened inquest proceedings, witnesses in the form of Mrs. Velemina Luthuli and also by the Honorable Minister, former Minister Jeff Hadebe, informed us how it is that Chief Luthuli was constantly surveyed.
Yes, I get that.
All the time. If he was constantly surveyed,
So you're saying that why were these people not called
besides
in the first inquest?
Besides not being called, my lady, why did they not come forward to the police and inform the police what it is that happened to Chief Luthuli? Because as people were constantly surveying him, surely they would have known exactly what happened to him. They would have seen his movements from the time he left home to the time when he went to the store.
Those people who are holding him under surveillance,
Correct, my lady.
do you think they would have come and say, look,
And that's the point. Because this is a cover-up. That's why they didn't come forward.
or
But if it was not a cover-up, they would have come forward to the police. They would have come forward to the police and informed them exactly what happened to the truth. So this builds on our argument that this whole incident was a cover-up.
okay.
Thank you, my
Yeah.
lady. It is
I'm
3:30.
sure you can address me further on this. I must say, I don't quite get it that, like, say for instance, these people who are keeping Chief Luthuli under surveillance are SPs. Do you think they would have come forward and
They
say exactly what happened?
They would not have come
They
forward.
would not have come.
They would not have come forward. But if indeed this was not a cover-up, and if it was in good faith, yes, it is known that Luthuli was under constant surveillance, and it is known that Luthuli was under banning orders. If they were acting in good faith, my lady, as policemen, as protectors of citizens in the state, they would have. That's the argument that
Oh,
I'm
okay.
proposing, my lady.
Maybe we should adjourn, or you want to complete? Is there anything that you want to add in respect of Van Wyk? I know it's still very early. You did indicate that later you will weigh his evidence against
Correct, my
the
lady.
evidence in the report.
It's just two aspects, and then we can adjourn, my lady.
Yes,
Thank you.
maybe.
As will be shown later, according to the statement of the station master, that is one Pretorius, he says that he was aware of the identity of the deceased upon arrival at the scene. What is curious, however, is why the identity of the deceased was not made known to Van Wyk by the station master whilst they were together at the scene for more than 15 minutes. Why is it that Van Wyk only became aware of the identity of the deceased after the return of the station foreman. It is curious as to what was being discussed for 15 minutes by the three individuals at the scene. We would like to bring to the attention of this honorable court that Van Wyk did not make mention of either Latterhan or Greyling being present with him at the scene. It therefore begs the question of exactly who was present at the scene. Van Wyk then stated that he was approached by the station foreman. The station foreman that then relayed that he was instructed by the station master to take over the protection points and that the station master would remain on the scene until the ambulance arrived. It is not clear where and when this instruction to the station foreman was given, and it is not clear if Van Wyk had left the scene when this message was conveyed to him by Steyn, whom it is said was the station foreman. And tomorrow, my lady, we will move to the points of inconsistencies between the evidence presented by Latterhan, Greyling, and Van Wyk. The stage, if we may adjourn. Thank you.
At this point in time, we adjourn until the 14th of October 2025 to continue with the presentation of the submissions by the prosecution team.
So Kaula, this is Kama, something that so let's do the exercise. Now, 14 October, like I didn't know is too long to continue the negotiation.
We commence at 10 a.m.
So today, say the correlation now.
Thank you for that.
That's good.